Supreme Court of India Dhanraj Aswani vs Amar, Mulchandani and another decided on September 9, 2024 SEC Online SC 2453 Facts of the case. Respondent number 1 arrested in connection with criminal case. While in custody, he apprehended arrest in connection another criminal case registered against him at the instance of the appellant herein. He prayed for anticipatory bail before the High Court. The appellant intervened in the proceedings of said anticipatory bail application and raised an objection that as respondent number 1 herein is already in custody in connection with criminal case, he cannot pray for anticipatory. The objection raised by the appellant was overruled by High Court, and it was held that although respondent no. 1 herein may be in custody in one case, yet the same would not preclude him from seeking pre-arrest bail in connection with a different case. Findings of the court. The purpose behind incorporating Section 438 in the CRPC was to recognize the importance of personal liberty and freedom in a free and democratic country. A careful reading of this section reveals that the legislature was keen to ensure respect for the personal liberty of individuals by pressing in service the age-old principle that an individual is presumed to be innocent till he is found guilty by the court. The court, on its own, should not try to read any other restriction as regards the exercise of its power to consider the plea for grant of anticipatory bail. Wherever Parliament intends or desires to exclude or restrict the power of courts, it does so in categorical terms. This is very much evident from the plain reading of subsection 4 of Section 438 of the CRPC itself. It was submitted on behalf of the appellant that a person already in judicial custody in relation to an offense cannot have a reason to believe that he may be arrested on the accusation of having committed a different offense. However, we do not find any merit in the aforesaid submission. It would be incorrect to hold that a person, while in custody, cannot have a reason to believe that he may be arrested in relation to a different offense. As a logical extension of this, it can also be said that when procedural law doesn't preclude the investigating agency from arresting a person in relation to a different offense while he is already under custody in some previous offense, the accused too cannot be precluded of his statutory right to apply for anticipatory bail only on the ground that he is in custody in relation to a different offense. Thus, contrary to the view taken by the Rajasthan, Allahabad and Delhi High Courts, a person, while in custody in relation to an offense, can be arrested in relation to a different offense, either after getting released from custody in the first offense, or even while remaining in custody in the first offense. In such circumstances, it follows that a person, while in custody in relation to an offense, can have reason to believe that he may be arrested in relation to a different cognizable offense. We find no restriction in the text of Section 438 or the scheme of the CRPC precluding a person from seeking anticipatory bail in relation to an offense while being in custody in relation to another offense. In the absence of any such restriction, we find no valid reason to read any prohibition in the text of Section 438 of the CRPC to preclude a person in custody from seeking anticipatory bail in relation to different offenses. The option of applying for anticipatory bail in relation to an offense while being in custody in relation to a different offense will only be available to the accused till he is arrested by the police officer on the strength of the PT warrant obtained by him from the court concerned in the present case. We have decided the issue of maintainability of an anticipatory bail application filed at the instance of an accused who is already in judicial custody in a different offense and have reached the conclusion that such an application is maintainable under the scheme of the CRPC. In view of the aforesaid discussion, the present appeal must fail and the same is thereby dismissed.